Hello, and thank you for joining us today. Brittany Spence here with the British Complementary Medicine Association, and I'm joined today by Mr. Christopher Head, who is the director of the Coffee Klatch Group. We're going to be talking about GDPR hysteria today. But first, I want to give you a little background on Christopher here. He is a barrister. You qualified in the late 70s, I believe. And you were a translator of law and a publisher of law for the courts, and worked 10 years in science law, where you were translating law for scientists, as well as you've been working the last 20 years with small businesses. And the message that you guys usually hold is turning law into something you can use. And I guess that kind of means making it easily understandable, for small businesses. Is that fair to say there, Christopher?
Absolutely right, Brittany. Thank you. And it's really nice to be here. Yeah, the translator of the law is really my phrase for it, of converting all this stuff that people look at and think, well, they don't look at it because it's all so scary and bleak. But the time I spent in law book publishing, even lawyers do it. A lot of lawyers don't read the law, they read the commentary on the law. And so that's the translation there. And then the translation for the scientists was in business with a big PLC. But so we were exporting stuff, all over the world. But these guys were scientists. And they didn't know about the law. And they didn't want to know about the law, but they wanted to know how to make things work.
Yeah.
And that's what we're doing for small business as well. We're creating a safe space for people that they can stand on, that they know that something's not coming down the pipe from
well, it's, as you were saying with it, translating it, kind of simplifying it in a sense. And that's what we're trying to do today, because this GDPR, as we were talking before we started, it's just become absolute hysteria. And it's being overcomplicated. We're seeing, it's some of the ads that I'm seeing for it. It's like big rain, dark clouds, and, followed by a super expensive package to go with it. It's some of them people are trying to get people in with all sorts of stuff with way too much information, overcomplicated.
Tens of thousands of pounds in some cases. Now, if you've got a huge organization and you're, I guess Facebook is probably spending more than £10,000 on GDPR compliance, I guess. Yeah. But the thing is, if they get it wrong, the fines they face are something in the region of $1.4 billion.
Right.
If they got the top level fine under GDPR. But for the rest of us, there aren't 10,000 information commissioner inspectors waiting to descend on us in a horde. They've already said they're trying to help us to get it right.
Yeah.
This is not, and all the fear-based stuff is, first of all, it's horrible, and secondly, it's unnecessary. There isn't this great fear thing there, and the hysteria about it is completely misplaced.
Yeah.
Everyone's thinking 25th of May, and our time of recording, that's tomorrow.
Yeah. Well, this is it. Questions are still coming in. There's the ICO is actually still dripping out little bits of information. I was speaking to one of your colleagues the other day, and she was saying that she'd just gotten another new document from them on a piece of something. So, it's still being created in a sense. It's still being processed. And
as far as, in English law, there's a data protection bill which is going to incorporate the GDPR into English law. It hasn't been passed yet.
Okay, right. So that says it all in terms of
even the government hasn't got their GDPR up to speed. Let alone the rest of us. It's a process, Brittany, that we're starting now. Yeah, and the Information Commissioner said, we're going to roll this out over a year. We're going to help and guide people. There will be more guidance coming out, I'm sure.
Yeah.
Yeah.
So, I mean, as you said earlier, the big key thing that I, want to highlight, as I said to you before, this webinar is for therapists. And so, I mean, everybody who's watching should be really good at sitting down, taking that breath. That's it, grounding and breathe. And that highlighting that the 25th, tomorrow, isn't a deadline. It's actually a beginning. It's a starting point.
Yeah.
And
it's not a starting point of panic. It's just a starting point of a process.
Yeah.
And some people are already some way through the process, which is great. You can be a bit more relaxed about it. But what I don't want to suggest to people is that you can relax and do nothing if relax means do nothing for the next 3 months, I certainly would.
Yeah. Okay. Yeah. That's too much deep meditation there.
Quite. Yeah,
so yes.
Although you have to get the meditation still out, you also have to put it away.
Happy medium.
Exactly.
So yes. So I mean, one of the things that I want to start with is highlighting where therapists stand in terms of GDPR. I mean, are they classified as a micro business?
There's no technical classification of micro or macro. I mean, I suppose there is in terms of micro, that there are some particular obligations on very large businesses. And when people say, well, it's just me, I'm a sole trader. Yeah, you're still a business. You're still holding records for your business. GDPR applies.
Yeah.
GDPR does not apply to your own home address book. You don't have to do compliance processes on the address book of your friends.
Right.
Yeah.
Right.
But the moment you're starting to have a business enterprise, then GDPR is going to apply.
Yeah. Excellent. Great. Okay. So what we're going to do is I have this PDF that is from the ICO's website, and I thought it would be nice if we just kind of go through these 8 steps that they provide for us. And I've got questions that came in from our members and therapists, as well as some organizations. And we're just going to go through that list, talk about the list, and answer some of those questions as we go through that list.
Sounds like a really good plan.
Excellent. Great. So let's get that open here. And we can start from there. So as we were saying, so step 1 is just simply knowing that the law is changing.
And everybody and the people who are here do.
Yes, that's it. Or they wouldn't be here.
Exactly. So there are 8 steps. You've already done the first one. Yeah, you're already 12% compliant.
Yeah.
Yeah, how about that?
So doing good. So, so one of the things is understanding how this could affect your business and identifying anything you need to alter to comply with the law. So, one of the questions that we have in here is, somebody who they say, do I really need to do anything differently if I don't have a website and I only keep paper notes? Is GDPR going to apply to them is what they're asking.
Well, first of all, it'll apply to them. And whether they need to do anything different depends on what they're doing now.
Mm-hmm.
Yeah. So if they're just keeping paper records, they need to check, for example, are they keeping them securely? Right? It's silly stuff. It may feel like, but it's obvious. Locked filing cabinet, not left out, no files left lying around on the kitchen table when the kids are around, everything put away. A little processes like that. And the other thing they may be wanting to look at is their sign-up form with clients, to be clear to the clients about what they're doing with the information they're holding. To say on their sign-up form, this is the way I hold the data that I collect about you.
Right. So having that actually on their sign-up form, their consultation form that states where it's being kept.
I think it makes sense.
Yeah.
I mean, just paper records, and I keep them in a log filing cabinet. A little statement. I care about the security of your information. Yeah, and if people are in a professional organisation that has a sort of patient confidentiality obligations built into it, say so. Why not? GDPR, and when you read about it normally, it stands for the General Data Protection Regulations. But how about we roll back to this one? It's get deeper personal relationships.
Great.
Yeah. It's about being respectful with the information you hold. If you were going to a therapist yourself, what would you either want or expect them to be doing with your data?
Yeah. Well, keeping it.
Turn it around.
Yeah.
Turn it around. Just look in the mirror.
Yeah.
Yeah. This is good Sufi practice. Look in the mirror.
That's it. Yeah. And that's it. I mean, you'd want them to be keeping it safe. is the main thing.
You wouldn't want the kids to be reading through your session notes and laughing about them over supper, would you?
Yeah, that's it. Exactly. Absolutely not. Yeah. So okay. So in that sort of sense, if somebody has no website and they're just keeping paper forms, simple answer to that really is make sure it's being kept safe and have that on their consultation form that they're keeping them safe. That's the real major change that they need to make if they're not doing that already. Step 2, and to keep a record of the personal data you hold and why. So going through this, the names, emails, the main sort of things in this as well is, as therapists, our information also goes into the special category data.
Absolutely.
And so, and so that data goes into slightly different category in a sense of why you're holding it and how long you're holding it. I mean, we did have a question on here that was asking how long, the records, the private records are held. Now, if I'm not mistaken in that answer, I don't know if you have a specific answer to that, but my understanding is the answer for how long they're holding that private information, the health information, varies from insurance company to insurance company. Is that correct to say?
I believe so. And the point is, check with your insurer.
Yeah.
And if they say, we want you to hold the information for 10 years, fine, hold it for 10. If they say, we want you to hold it for 20, hold it for 20. There's no specified amount. It's but you need to take a sensible shot at what you need to hold. But don't forget, you've got security implications. So if you're paper-based, is your loft going to start filling up with client records for the last 20 years? Yeah, I mean, we keep our our accounting records for 10 years, and there are boxes in the loft. I mean, actually, I'm sure the boxes go back more than 10 years. But every once in a while, you go up there and just chuck out the ones that say throw out before 2010.
And I mean, this is the thing. I mean, these, like you say, these records can add up. And I mean, I know a lot of people are moving to digital note keeping in this sort of aspect. And in that sort of sense, I think there's encryption that is important. I don't know, I haven't heard a lot of therapists talking or thinking about that. But
it would be very wise.
There's software out there to encrypt everything.
It's not that, if you're using reasonably modern, if you're, I don't know whether therapists typically are using Apple's or using Microsoft, but if you're using Windows 10, I mean the latest version of Windows, there's encryption there.
Yeah.
It's a nuisance to implement it, but once it's done, your kit is encrypted.
Yeah. This special category data and how long people are holding it, and and in terms of encrypting, we said already with locking it up that needs to be on that consult form there before you starting to take that information. I guess stating on there that if you're keeping it digitally and that it's encrypted, put that information on there.
Yeah. No.
And how long that you're keeping the data.
there's a point when your consult form is just going to get so why not have a separate bit of paper,
right,
that says, and I mean, people have a data policy that goes on their website if that's sensible, but why not have if you're on paper, have a data policy on paper that doesn't clog up, but doesn't, just a reference on the on the consult form that says, I've got a privacy policy and a copy is attached. This is it. Anytime you want a copy of it, just ask me and I'll give you one.
And equally, if it's on your website, you can refer them to your website's privacy policy.
That's a really easy place to do it.
That's a good suggestion for people to add onto their form without it getting clogged up.
Lawyers have this general sense, and I hope I'm managing to resist it, that somehow if things aren't clear, adding an extra 1,000 words will make it clearer. This is not normally true for anybody, and it's not even true for lawyers either.
Yeah.
But it's just somehow we have this reaction of, oh, well, if I explain some more, it'll be better. No, explain less.
Yes.
Explain more clearly. That's
right. Yes. Yes. Exactly.
So one of the questions you showed me earlier, Brittany, was somebody saying, do I need a solicitor to draft my privacy?
Right, yeah.
Can I just do it myself? I think, no, don't let the lawyers anywhere near it.
Right.
If you can do it plainly and clearly yourself, do it.
Great.
And the other thing is, because then what will happen is it will express you. I really want to just have a little sidestep at the moment about consent, because there's all these opt-in mails that we're getting are about consent to be on marketing lists. And it's a completely different place you're in with people who've been clients, where you've had a contract with them. Yeah, you're not processing their data on the basis of consent. Your lawful basis, when we look at the thing, your lawful basis is probably contract. Now, if they're a former client, your lawful basis may be legitimate interest, that your legitimate interest in keeping your insurers quiet, or keeping your professional body quiet, or keeping your supervisor, if you're in a type of therapy where you have a supervisor to make sure you're staying on track yourself. I know that's a way it works in some environments, so that your supervisor understands what's going on. Then you may need to be keeping data on former clients. Do you need to tell them? Yeah, I haven't talked about that one actually. Quite possibly. Yeah, it would be polite, wouldn't it? So I think
just let them know
that's
I'm
the
still
measure.
holding that data.
But but don't do it today.
Yeah.
Because they've got a zillion emails today. But as part of your process, sometime over the next couple of months, if you wrote to the clients you haven't been in touch with for ages and said, just to let you know, you will have seen all the stuff like GDPR and all the fuss about it. And as part of that, I did a new privacy policy, and here's a copy of it.
Yeah.
And as part of that, I am still holding your information. I will continue to hold it for X years, according to whatever it is. And because I need to do that to satisfy my insurers. Yeah?
And I mean, in one sense of that, I definitely encourage people to probably listen to that bit, because I think we all see that our inbox is full of these really annoying emails with the opt-in, which I want you to go into a little bit more when we move on to the PECR.
Okay.
But in that sort of sense, with when they do inform them that they're still holding that information and how long they need to hold it, there is that right to be forgotten. Now, do clients have the right to be forgotten with medical and health records?
Very good question. They don't have an absolute right to be forgotten about anything.
Okay.
Right. Apart from things that you are holding on the basis of their consent.
Okay.
Yeah. So if they're on a marketing list, they have an absolute right to be off your marketing list and forgotten by that. Well, they won't be completely forgotten, because what you will have, if you've got a MailChimp or Aweber or whatever, one of these platforms, is there will be a record that they opted out, that they unsubscribed, which bizarrely enough, you need to keep.
Yeah.
Because deleting data is processing the data,
Right.
and you need to keep a record of the processing of your data. So you have
Right,
to know.
yeah.
You get into these logic. You just think, shall I find a bucket of cold water and give it to my head? Because it would probably make sense.
So going on with that one are the personal details, are they allowed to be shared with professionals and paraprofessionals? I'm presuming the answer to that is yes, as long as you have stated in there, the client is aware that you're sharing that with other professionals, because I mean, a lot of us work jointly with other professionals, and as long as you make that clear.
Gold star.
Yeah. Yeah.
That's exactly it. Yeah.
And that would be in your privacy policy is where you would have that information, letting them know.
So if you were planning on sharing data with somebody, with another therapist, if I was the client, I would want to know when you were going to do it, who you were going to do it to, and why. And I would like to know those things, not in a general sense, in a privacy policy of, I may share your information with other professionals if I think it's going to be helpful.
Yeah.
But because I think, well, hang on a minute, who?
Yeah. Yeah.
And what are their qualifications? And, I came to you.
Yeah.
How come now suddenly I find myself actually being a client of somebody who I've got no connection with?
Right.
I mean, I'm just thinking about someone who, as a user, as it were, would I like that?
Yeah.
So put your user hat on.
So I mean, more as we said with this, then in a sense, then more specifically, literally case by case of highlighting that.
I would think so.
Yeah.
That's my immediate reaction is specifically disclosed.
Okay.
Precisely, and part of the notes, keep it in your consulting notes.
That you've done that.
That when you asked and what you said.
Yeah.
So you've got an audit trail. A lot of this stuff, you need to have a record.
Yeah, of that.
It mustn't consent over the phone. Now, I don't think you probably don't need to go as far as getting the client to sign off on it.
Right. Well, and I mean, that goes into this next sort of question of, are signatures required to agree storage of confidential information? I know that some professional bodies do require signatures to for every session. So every time you're taking new notes about the person, they require you to get consent to save those notes on it. Now that is the professional body's choice, but is that something that you would recommend as a whole? Do all therapists need to be doing that? Or
I wouldn't have thought it was necessarily from a general point of view.
Okay.
I would have thought absolutely essential as part of as your professional certification.
Yeah,
if that's your professional body.
Yeah, if that's what they require, that's what they require. But if you're not part of that body, then it's not necessarily.
I wouldn't think so, because the fact that the client is there and keeps on coming back, and they see you taking notes, I would think is more than suggestive of the fact that they're consenting to that.
Okay.
This is special category data that we're talking about.
Yeah, that's right.
So although the if you like, the fundamental basis for processing the data for a client is going to be the consent. Yeah, that's the Article 6 processing, or possibly for ex-clients, it would be legitimate interest. But when you look at the special category lawful basis, which goes on top of the normal one, as it were, you have to have a normal basis of processing and a special category basis as well. So the special category basis is almost certainly consent. It's perfectly possible to have more than one lawful basis of processing.
Right.
You don't have to pick one and stick with it, as it were.
Okay.
But so it would be perfectly legitimate for you to say, in relation to data, if you like, I'm not sure whether it's consent or it's preventive occupational medicine, right? And I'm going to, as it were, work with both of these. The disadvantage of consent is the moment a patient or a data subject removes their consent, you then have to stop processing the data.
Right.
So it's probable that in terms of meeting your insurers, sorry, I'm thinking as I go actually, in terms of meeting insurers' requirements, they will probably be much happier if your primary processing lawful basis with clients was the contract, and the secondary one for the special category data was preventative occupational medicine.
Right.
Because then the client would not be in a position to say, I withdraw, and you wouldn't be under an absolute obligation to give them to delete all the information. You then would do the legitimate interest balancing act.
Right.
Where's the harm? Where's the problem?
Right.
Question. So thinking it through, I find I'm often wiser in my mouth than I am in my head. I have to remember to listen to what I say. So I'd say, go for contract for the Article 6 and go for preventative occupational medicine for the Article 9.
That sort of sense, I mean, they don't necessarily need to have that signature after every single session.
No, because the signature after every session would be a consent basis.
Yeah.
And
it's part of the contract in the beginning. Exactly. To have that consent.
And I think there's a danger under GDPR of getting lost in this consent problem.
Yeah.
There's an awful lot of talk on the internet and in the forums and so on about consent in relation to GDPR, because they've already got the people who first got overexcited about it were the people doing marketing. And then that's where the PECR stuff comes in.
Yeah.
Because that's where the consent is required.
Yeah.
But the Information Commission has been very clear, consent is often not the right basis.
Right.
But in terms of this identifying why you have personal data and how you use it, what you're working out is, I'm holding personal information in my calendar. Yeah? And then I'm holding personal information in my email box.
Yeah.
I'm holding personal information in my CRM.
Yeah.
So that you can actually start to pick out what you're holding.
Yeah.
And the spreadsheet will probably take some time to build up.
Yeah.
And you wake up, bolt upright at 3 o'clock in the morning, and think, and of course I'm keeping stuff there.
Yeah.
And then my suggestion is just get up and write it down and then go back to sleep.
Oh, I'm not letting GDPR wake me up in my sleep. There's no way. You do this for a living, so it's different. Yeah, indeed. And this, with this as well, though, I mean, somebody's saying, what records are required when doing seminars and talks and information taken of potential clients, and what written proof needs to be kept for all marketing approaches? So I mean, if I'm
brilliant question, Brittany. So if you're doing an event and people are signing up, right, to go on a mailing list, right, have a sheet that says sign up for my mailing list.
Yeah, right?
Specifically. And if you want to say, if you sign up for my mailing list, I'm going to be sending you a mailing. I'm going to link you to my blog post, and I'll be sending you a mailing probably every month, or probably every couple of months.
Yeah.
Or
be clear on how often you're going to be
roughly
in their inbox.
And
so how long would they, if they took that on paper, that's that proof of consent, how long do they need to keep it?
Keep it forever.
Yeah. Now, what if when they send them that first email, if it has, they've got to consent with that first email, they won't need to do that because they've gotten the consent on paper.
Got the consent. What they need to send with the first email, the first thing that goes out, is an unsubscribe.
Yeah.
So people can get out.
Yeah.
But the whole thing about, I mean, do we want to have a little dive into the opt-in emails that people are doing?
We'll go for that. I mean, this section's complete. We've only just got one little bit on this, because we're going to jump into the PECR. So have a plan in case people ask. One of the questions that came on this is, what do I do if somebody reports me to the ICO saying that they didn't want to be contacted by me?
If first of all, I hope that they would have unsubscribed. If they didn't want to be contacted, that would be some marketing approach, right? If you didn't have an unsubscribe button on your emails, then the Information Commissioner will be coming to you and saying, put an unsubscribe button on your email, please.
Yeah, simple as that. It wouldn't be, people are panicking in that sort of sense that they're going to get into major trouble if they do send that email that somebody didn't want after tomorrow,
If you send out 10,000 emails to people on a bought-in list that you've never heard of, and 40 of them report you as spam, then you might get a slightly frostier call from the Information Commissioner office. If they found, if they could be bothered, and bluntly, but I mean, therapists aren't going to use bought-in lists. It's
no.
Make any sense, does it?
No.
It's going to be local. It's got to be local connections, because people have got. Oh, no, it's because people are doing therapy over Skype now, aren't they? But don't use a bought-in list. Unless you have a very, very clear reason for doing it.
Right. Okay. And I mean, we spoke already in the sense of, what to do if people ask about the data that you're holding for them, in terms of right to be forgotten, or, I mean, they can request can they request your notes? Because I mean, typically therapists were taking these notes privately, in a sense, of the client themselves. They're not looking at our notes. Do they have a right to request the notes that we've taken about them?
Oh, that's a cracker, isn't it?
I mean, that one's just come to me.
It's really, but no, it's a wonderful question, and you can tell. I mean, that's a politician's answer, isn't it? What a good question. I am now not going to answer it. I don't know, Brittany. Right. So, I mean, the starting point is it's personal data you're holding about me. I should be entitled to see it. Now, whether you might make the judgment that actually it was in the client's interest not to disclose it, that actually it wouldn't particularly help them if they knew you'd written at the top of the first page, mad as a March hare. That might not actually be very helpful.
I hope nobody would be having something quite so blunt. But I mean, our typical notes, I mean, we have the subjective outlook and the objective outlook, what they've come in telling us and how we perceive that, in a sense. Yeah. And, in some senses, that sort of assessment, I would have on there, why I think this connection is happening, but it wouldn't be something I would share with them, because I could alter
quite
their outlook.
Right. I'm not going to attempt to answer that question.
Yeah.
But
I do see
cracking a question. Mark it down, Brittany. Let's have the question in the group.
Yeah, okay. And I'll pop an answer to that at another time.
Because I'd really like to see what other people in the group are thinking about that as well. Because it's a corking little question.
Yeah.
I'm guessing that before people actually start a session of a series of sessions with a therapist, there's probably going to be some email communication with them.
Sometimes, yes, I'm sure. Sometimes
or meeting, but I mean, there's going to be some way. So either if it's only meeting, have something on paper, give them, and if it's by email, either have a link to the privacy policy in the email sign-off, or make sure that one of the early emails sends the privacy policy.
Right. That's good. Yeah. Having that on the bottom of your email, I think, is probably good, because then it just starts that process of consent or whatever you want to say straight from the beginning. It's
Yes. I think we want to stay away from consent for the client.
right.
It's awareness.
Awareness. Okay.
Rather than consent.
Yeah.
Should be the thinking.
Yeah.
Because if they're aware, they can back off if they don't like what they're seeing. But as a therapist, you've got to have your own standards about what information do I need to keep in order to do my job. In order to do my job effectively, the stuff I've got to have. And, and if a client won't allow you to do your job,
well, then you can't work together, can you?
My guess is you have to say to them, thanks, but no thanks.
Yeah. Well, going past the special category data, in when it comes to collecting their personal data, I've got a question here that is saying, when clients provide their email address and phone number for reminder services, do they need to be informed that you will be using it for this specific purpose, or can that just be presumed?
No, that's fine. So long as, I mean, when you're collecting someone's phone number, for example, make it clear because there's going to be some sort of process you have of a box tick and something they do, or they're going to sign to say they're going to write in their number and then they're going to sign the form or whatever it is. Make it clear, I'm going to hold your phone number so that I can send you reminders of our
appointment. It would be good to have that stated then.
Stated that.
Okay.
And so that I have your phone number on my phone, so if you call me, I know who you are.
Yeah.
And so that if I need to call you, because if I have to cancel an appointment at short notice, so I can call you.
Yeah.
Yeah.
So it is good to have that stated. It shouldn't just be presumed.
At the point when you collect that phone number.
And I mean, in the same sort of this as well, that was a question in terms of the reminder service. But if you're collecting the number and email that you intend to use for a newsletter, I presume that you need to have a box on that form that says to not opt out, but to opt in, to click the button, tick the box that says, would you like to receive? Yeah, exactly.
But you can express it more positively if you want to, rather than, I mean, would you like to receive, I mean, however you want to say it, but you can draw people in.
Yeah.
You could say, I produce a newsletter, maybe once a month or once every 6 weeks. It provides these things if you want it.
That's the thing, I think, is a good thing to remember with all of this, because I mean, as we were saying with these emails and stuff, a lot of the language everyone's using is very stiff and very rigid and very robotic, and trying to keep some of it quite friendly and be yourself and just take the edge off the seriousness of all this and be playful even with some of it. So another question here as well is, as we take medical details, which is classed as special category data, what are the reasons under Article 6 and 9 that we choose? I myself don't know what Article 6 and 9 are.
Okay, so we covered that earlier, actually.
We did, okay. I didn't know if that was...
went past you, but I can just reprise it very briefly. Article 6 is the general lawful basis of processing.
Right.
And Article 9 is a special category.
This was, I remember this now, okay.
And you have to do both. And so I'm saying, I think for clients, your Article 6 basis is the contract, actual or negotiated. Yeah. Negotiating. When the treatment is over, sessions are finished, you're holding the records, I think, for legitimate interest, which is your protection. The special category reason is, I think, probably reason number H, which is the prevention of occupational medicine. If you're a health professional subject to a secrecy obligation. So it might be that, possibly, if you've got people who aren't subject to a professional secrecy obligation, then it would be consent. Okay,
so that is that for 5. On number 6 here, check your security. I think
we talked about this,
Yeah.
We've done this because we talked about filing cabinets, we talked about encryption, Yeah, I mean,
yeah.
good
I've
things
got
on the list.
just one little question with this actually is for those keeping only paper data, is that for their privacy policy, is the statement simply all records are kept in a locked cabinet or on my person at all times? Is that a sufficient statement?
I would think so.
Yeah, great.
It's simple.
Yeah, it tells you exactly.
Yeah, it tells you exactly what's going on.
Number 7 here is develop a process to make sure you know what to do if you break data protection rules. I mean, you know, in this sort of sense, if paperwork is lost or stolen, things of this nature, you know, if they're not disposed of properly, et cetera, et cetera. You know, do you have any kind of just nutshelled advice on what a therapist should do if they did say say they had their paperwork, their notes on a tablet or something, and that tablet was lost? What should their process be for that?
If the tablet was encrypted,
then there shouldn't be a problem.
There shouldn't be a problem. If they, I mean, I don't know on my laptop. I mean, I'm not the techie, as you know, Brittany.
I imagine a lot of therapists aren't.
Yeah.
That's it. We were talking about that. Well, that's it. We know you're not techie if you're using quill pens.
But I do have the laptop as well. You can tell. My laptop has a you know, a thing, so it can be found. I mean, Techi's actually in South Africa, but bizarrely, he can tell where my laptop is, even when I can't. Yeah, there are ways of doing these things.
Yeah. But if someone did lose some form of notes, what would be?
Just what it says on the tin.
Yeah, just
which is if you're really worried about it,
contact ICO.
Contact the ICO
yeah.
and say, look, you know, I do this and this is what's happened.
Yeah.
What do I do next? These guys, the ICO, are trying to help you. Yeah. Okay, they've got the power to fine if you're really stupid about things. But you've got to be, I think you've got to be more than stupid. Yeah, you've got to be villainous. I think you know, you've got to be really scummy for them to be starting to come after you.
Yeah.
Or you know, just completely ignoring the whole thing.
Yeah.
But if you think there's a problem, why not phone and say?
Yeah.
And there's a question. You see, if you look on the left-hand side, it says if the breach is likely to result in a high risk to the rights and freedoms of individuals, contact them directly without undue delay.
Right.
Yeah. So if you really think there's a problem, yeah, and
say, for instance, if you were working with a celebrity, for instance, quite a high known name, and you've got confidential notes of, you know, a breakdown or some serious thing going on with them that could massively affect, you know, if somebody got their hands on those documents, I suppose something like that would be a slightly different scenario.
Pick a horror show scenario.
Yeah.
No, but see, and so put yourself in the situation of the data subject.
Yeah.
You'd want to know.
Yeah.
Yeah. You could get your PRs alerted to start to build the walls around what you would need to do if the stuff came out. Yeah. You wouldn't want it to come as a total shock to you. You would have professionals around you who would be in a position to do something about it, and to as it were pre-arm the situation to keep you protected.
Yeah.
So what would be fair to your client in that situation? To keep quiet and hope nothing happened, or to let them know? It's like it's a no-brainer, isn't it? When you think about what could go on. Yeah.
So I mean, in that sort of sense, then, if you did have, you know, the biggest sort of thing that, you know, worst nightmare, as we say, is losing those notes, contact ICO and contact the clients directly. Client first. Okay.
If that's the situation you're in, don't bother speaking to the ICO. Yeah, I mean, not straight away.
Yeah.
The first person who needs to know is the person who's most affected.
Yeah.
Who's most affected? The client.
Yeah. Okay. So, but more importantly, let's just try not to let those things happen. Let's keep it,
Thank you.
keep it
real.
encrypted and keep it locked up. So, you know.
Exactly.
So excellent. Okay. And step 8 here, and I love this one. Do not panic.
Right. The Hitchhiker's Guide advice is absolutely it.
Yeah. I mean, and as we see here, that yellow writing there, you know, that's wrong. That information, it's not going to stop them ringing patients to remind them about appointments. You know, there won't be fines that are going to put these small businesses out of business.
No.
And, you know, all these things, you know, just chill out with it and do your best. And that's really what matters in terms of that. You know, just a couple of, you know, this is the kind of point that I'm going to keep here of just remember, don't panic. I want to cover just a couple of the PECR, if you want to tell us what that means, because I haven't heard people using that abbreviation. Everybody's saying GDPR.
PECR stands for the Privacy and Electronic Communications Regulations, 2003. What it does is it controls people's direct marketing and limits it to people who've consented to it, whether it's by phone or by email.
Right.
So if people haven't consented to receive your marketing mails, don't send them. Yeah. And this is what all these opt-in emails are about.
Let's talk about that.
The slew of those things is people trying to keep you on their marketing lists. Now, if you're talking about people who are clients, do not send them an opt-in email.
So
you already have a proper basis for emailing, for having them on your list.
Right. So do not send them one of those emails and clog their inbox up further.
Absolutely.
At this moment.
For the people who are on your mailing list, right, if you have a long mailing list and you're not, you know, you think, well, I've been a therapist for 20 years and I've got all these people on my list, what am I going to do? The answer is, for the moment, do nothing, including don't email it. Yeah, just do nothing for a month, roughly. During the month, if you want to do something about your list, look at it and think, where did these people come from? Did they sign up on my website? When they signed up on my website, were they agreeing clearly to being on my newsletter? If they were, tick. I can ta-da, right?
Yeah.
So long as I have been sending them a newsletter, and it wasn't, the last newsletter I sent was 3 years ago, in which case you may need a slightly more nuanced way of reapproaching them.
Yeah. I mean, I think, again, the key thing with that as well is make sure you have that unsubscribe button at the bottom as well.
That's the critical one. That's the really critical one.
And with that, I mean, this was a topic that I've seen discussed is MailChimp GDPR compliant?
Yes.
Yes, they are now, because
all these standard platforms are.
And what about the fact that they hold the record of unsubscribed clients?
It's an interesting one, isn't it? Because the fact that somebody unsubscribes, you were then processing their data to unsubscribe them. I mean, when I say you were, I mean MailChimp was, but I mean it's they're the processor, you're the controller.
Yeah.
So you need to have a record of the processing.
Does that violate a right to be forgotten?
No. Because you, as the data controller, need to be able to prove they asked me to forget them.
Yeah, right. How ironic.
So you have to keep the record that says that they asked to be forgotten.
Yeah. Right. Yeah. So there we go. I mean, that's been a common question in that regard. So I mean, there's no in that sort of sense, as you're saying, you know, most of the email platforms or all of the email platforms, the big ones at least, are GDPR compliant. So there's not really a specific one that is recommended. Of course.
Just check if you go onto your browser and put in MailChimp GDPR compliance.
Yeah.
Aweber, GDPR, whatever, they'll tell you.
Yeah.
The American ones should be, and almost certainly will be, if they're still going to be in business.
Yeah.
They're going to say, and we're part of the EU, US, and Privacy Shield, and the Swiss US Privacy Shield.
Yeah.
And
so,
and you'll be okay.
And, if you're using...
One quick one. I think the thing to step back from is people are wondering whether the platforms are GDPR compliant.
Go to their...
Turn the mirror around.
Yeah.
Am I GDPR compliant?
Yeah.
That's a more relevant question.
Yeah. I mean, well, this is what, just putting on your privacy policy, because it lead them over to their privacy policy. You're letting them know that you're using that platform, and you lead them over to check them out.
That's a simple way of doing it.
Yeah.
It's a simple way of doing it. I've just done one for a client that uses MailChimp, and I said, we use MailChimp for our mailing.
If you want to know more.
And she has a link to their privacy policy.
Yeah. I mean, that's my way of thinking with it, is just pop them over to that, Yeah. So, I mean, but then going interesting on this one then is using a Facebook pixel on your website means that as soon as they visit your site, their data has been collected. So how is it possible for them to opt into this when it is automatic?
Right. Okay, that's a really interesting one. You're not sending them a marketing mail. What you're doing you're enabling Facebook to present an advert to them.
Mm-hmm.
I think in your cookie policy,
right,
on your website, you should say, I'm using Facebook, and so I wonder if you need to actually say I'm using a Facebook pixel, whether that would scare people too much. I mean, if you want to, you can say I'm using a Facebook pixel, which means that if you are on Facebook, right, and you've been on
they can opt out of that through Facebook.
Oh, well, in that case,
that's their problem. That's their thing to do.
Right.
This is where I'm wondering with different things with GDPR and in some aspects, it's just tricky because, I mean, there was a question here of, what's the difference in cookies and GDPR? Will my cookies notice cover me for GDPR? Because in some instances like this Facebook pixel, it does in a way identify them as an individual person.
Even though it doesn't, I mean, even though you can't tell, if I visit I did visit your website. Did I visit? Yes, I visited your website. Can you tell from your analytics?
Me personally, I don't think so. I certainly wouldn't know how, but Facebook can.
Okay, so
yes, and I'm selling that in a sense over to Facebook when I use an ad and use that data.
Yeah. That's really interesting one, isn't
it? So that's the thing that is curious. Is that GDPR or is that cookies?
Right. The distinction is not relevant.
Right. Okay.
Yeah. It's, are you being clear with people what you're doing about their personal data? Personal data is something that makes them identifiable, right? This Facebook pixel is making them identifiable, isn't it?
Mm-hmm.
So I think it would be prudent, and it'll be interesting to see how this plays out, because I mean, this is not my special subject. I'm gonna pull the quill pen clause on you. But I think if you want to be completely transparent with people, you could say you may see Facebook ads as a result of having visited my site because I'm linked to Facebook on my site.
Mm-hmm. And in that, it's up to them to go to Facebook.
And you can say, if you want to make sure this doesn't happen for you, you have to drive that in Facebook. I can't do anything about it.
So
that'd be a very nice way of doing it, wouldn't it?
Yeah, it is an interesting one. I mean, as well, you can use that email list as well to upload into your Facebook marketing. So I suppose when you are collecting that email and letting them know that you're going to be using it for, I mean, for marketing purposes as a whole, and that just doesn't necessarily mean marketing to the inbox. That's marketing on social media, potentially Google ads, digital ads generally.
Right.
Right. And so it's highlighting that, I suppose, with that email list. I mean, in terms of the
highlighting, I mean, it's not, you don't have to highlight it, but you have to make people aware.
Yeah.
And the cookie policy is the place to do it.
Yeah.
And the cookie.
So that's all
I
cookie
think,
policy.
Well, I think so. I mean, because it's something that people are, as it were, getting as part of visiting your website.
Mm-hmm.
It's not linked to their email address. Now, if you're using that email list to populate your Facebook ads, then I think that might be something that you should be saying in your
both privacy policy and your cookies, I suppose.
Yes, I'm not quite sure. I'm not going to do drafting over the phone, as it were, Brittany. But something worth thinking about.
Yeah.
Whether posted in the group, because it's a hell of a good question.
Yeah. Well, it's an interesting one because, I mean, I watched Mark Zuckerberg's conversation in Parliament or whatever when he's talking with all of them. And, you know, as a marketer, I comprehend how a lot of it works. It's not necessarily Facebook that's collecting the data. Technically, the businesses are collecting the data and then selling it to Facebook. So, you know, it's a different thing. And in listening to them and the questions they asked, they didn't understand how it worked. And that's been my concern with some of these, you know, some of these elements, in a sense, is that the policymakers that are making this, some elements, I do question if they even totally actually understand how it works, you know,
I'm sure you're right, Brittany. Don't forget, the GDPR was enacted in 2014. You know, so, and things moved on a lot in the last 2 years anyway. Most of the people who were actually voting on it won't have understood it.
That's it. That's
but thank you. You've informed me. And I've got some cookie policies to draft this afternoon, and they're going to be different as a result.
Excellent. Yeah.
But it's interesting to see how these things unfold. And I want to go back, because we presumably must be going. I want to go back to the sense of, this is not tomorrow.
Yeah.
This is not next week. Yeah. We're starting a process. You may put up your cookie policy and privacy policy during June.
Mm-hmm.
Yeah? And you then may decide in August you want to change it.
Right.
And you may decide in October you want to change it again.
Mm-hmm.
Yeah? As you get more specific, more clear, you decide, you know what, I think I can lose 500 words out of this rubbish.
Mm-hmm. Mm-hmm.
Yeah. If you can, or actually I needed more than 200 words. I was being a little bit cheeky with it. I need to express myself a bit more fully in some of these areas. So it's not a finished job.
Mm-hmm. You know, I think a lot of people will have their questions answered from this, but if they still feel like they want that extra support, they are welcome to jump onto that other package and jump into that affiliates group and ask questions once they're a part of that package. And I think that is all fair enough.
Yeah, Annabelle and I are there and ready to answer stuff, and I'll go and get the books off the shelves in the basement.
And that those groups are full of all sorts. I mean, I think, as we said, Annabelle she's on BBC this morning. She's been doing interview after interview with the big guy. So she's, obviously yourself, your stuff. She obviously definitely knows her stuff as well. And so anybody that's in those groups, you're well supported. And
what I'm enjoying about the groups, Brittany, is the support that the individual members are giving each other.
That's really it is.
See people not playing well, if my competitors are having a hard time with this, any great. Everybody's slightly thinking of, we have a common enemy. It is GDPR. We shall beat.
And that is lovely. There's one good thing that's come out of it then. It's so excellent. Well, thank you so much, Christopher, for joining me today. I really appreciate your time and you sharing your knowledge, and might see you in the group. So excellent. Great. Thank you so much, Christopher.
All the best.